Part of our commitment to putting Southeast Texas first means getting answers to your legal questions. On Wednesdays, we take time to ask the judge. And this afternoon, we are joined by Judge Randy Shelton from the 279th District Court there in Jefferson County. Good to see you, Judge.
Good to see you too, Jordan.
Hope you're doing well this summer. Let's get straight to it. This first question from someone who is pretty fed up. They say this heat is ridiculous and my apartment's AC just isn't keeping up. I've gone round and round with the maintenance staff. They've made several attempts to adjust the compressor and add coolant. Little success, they say. My lease isn't clear. Do I have a right to break my lease for this poor performing air conditioner?
Gordon, the short answer is yes. Landlords must repair conditions that substantially affect your health and safety, and the heat is definitely a health and safety concern. Notify the landlord by certified mail of any needed repairs. After the landlord receives the notice, the landlord has a reasonable period of time to make diligent efforts to repair the problem. Usually this reasonable period of time is about 7 days. If the landlord does not make a diligent effort, you can sue the landlord and get an order to repair the problem or terminate the lease. There is one other solution. You can also hire someone to fix the problem and deduct the cost of that from your rent, but you really need to get some legal advice before you start deducting the cost from your rent.
Yeah, I was going to say, I feel like the apartment complex, we're going to assume this is an apartment, right? Might come back to you and say, these people charge twice as much as our guy would have or whatever.
Exactly. But, you know, with temperatures the way they are, I think everyone is a little warmer in their home than they want to be.
That's a good point. AC is struggling to keep up everywhere. Okay, this next question. My partner and I have been together for 7 years. We've lived together for 5. Is this enough for us to be considered married under common law, or do we formally have to declare ourselves married?
Well, actually, just because you live together does not mean you're in a common law marriage. To be in a common law marriage, you must live together in Texas, have an agreement to be married, and represent others that you are married. Now, the agreement and representation that you are married can be proven by showing that couples knowingly filed as a married couple on their income tax returns, or one party carrying the other spouse on their insurance, the party throwing an anniversary party, or so on. But you don't have to register the marriage. It is you can be common law married. You don't even have to live together for any specific period of time. There is a way though that you can register informal marriages, which is what we call common law marriages.
Okay, and I guess that kind of leads us to my follow-up here is, do common law marriages have different rights and privileges than a traditional marriage?
There's only a couple of differences. First of all, you can get married in a traditional way if you're under 18 with parents' permission, but you cannot be common law married under the age of 18. The other thing is that if you've been common law married, but you live apart for 2 years, the court can presume that there wasn't a common law marriage in the first place. It's kind of like a common law divorce. Otherwise, a common law marriage is the same as a regular marriage. There's community property and debt and everything else that goes along with being married.
Well, I hope that helps for our viewer who had that needed that point of clarification. Judge, it's really good to see you.
Good to see you too.
Hope you stay cool. Speaking of those air conditioners, we appreciate your time. Friends, if you've got questions for the judge, go to 12newsnow.com/askthejudge, and there's a form that you can fill out right there.